Hello everyone, my name is Patricia Crossin and I'm a lawyer and I am a chair of the Special Educational Needs and Disability Tribunal. Firstly, I would like to thank SENAC and Patricia and her colleagues for this opportunity to speak to you today. Unfortunately, due to my commitments in other legal proceedings, I am unable to join you online. However, I'm very grateful for the opportunity to pre-record this presentation. So I would really like at this stage to talk to you about what to expect when a person, appellant, as they're sometimes referred to, arrives for the hearing of their appeal. So my comments are primarily directed to those people, as the Education Authority and the people who appear in these appeals are very familiar with the process and the format of the process. So the hearings are heard in the Tribunal Centre, which is situated in the Royal Courts of Justice, Belfast. The Tribunal Secretariat, who you will have dealings with from the beginning of the appeal, are there to guide you through this process. And I would really encourage you to ask questions of them, seek clarification of any issues you have, and they will help you from the beginning of the appeal up to the hearing, and if necessary during the hearing and subsequent. And they are there to assist you, so please use them. On the morning of the appeal and before the hearing starts, when you're seated in the corridor beside the tribunal room, sometimes there are discussions between an appellant and the Education Authority. Sometimes an agreement's reached, sometimes it isn't, and sometimes there are no discussions. It's really dependent in each and every case. But importantly, the tribunal member itself, the tribunal members, the panel members aren't part of any of those discussions. So that when everyone's ready, then the hearing commences. And the hearing takes place before a tribunal panel of 3 members. And we comprise of myself, a legal chair, and 2 lay members. And the lay members come from a variety of different backgrounds, some with experience generally in education, some with experience in special education. But very importantly, as a panel of 3, we are independent. We have no dealings with the Department of Education or the Education Authority. We are independent and we come to an independent decision on the appeal. As a panel, we will also have received the bundle of documents well in advance of the hearing. And that means that we have time to fully consider all the issues that are raised in the documentation and to be very conversant with everything that has been presented to date. And that's very important, as their information within the papers can be very specific, detailed, and especially where statements are concerned, quite technical in format. So that when you come into the hearing, therefore, you'll be faced with the tribunal panel members of 3, and we operate a round table format. So there will be a semicircle of chairs and tables, and that is the manner in which that we hope will foster good, very good discussions. I've now been chair of the tribunal since really its inception, and we're cognizant and are conscious of the fact that the parties will 9 times out of 10 have a working relationship going forward, and we aim to foster that. So the actual hearing does not involve anyone giving evidence, sworn evidence, and is more of an informal guided discussion of the identified issues, which may have been identified before the hearing commences. And I, as a chair, will guide the discussion around those issues, with the Education Authority giving their position first. This is allowed for by the rules, and they may ask for input from anyone they have with them, whether that's a school principal, a teacher, an education psychologist, a therapist, and then an appellant, the person who's brought the appeal, has a similar right, maybe to ask questions of those parties and then present their position in relation to the issues. And they may have brought someone with them who can do that as well, or they may in fact be assisted by someone who's with them in a representative capacity. Sometimes there also may be documents that are brought to the tribunal's attention just at the day of the hearing, and this is sometimes described as late evidence. Now, there has to be an exceptional reason for that to be included in the documentation before the tribunal, and that's to ensure that no one's ambushed by any information. And again, if that's the case, both parties have an opportunity to present their position in relation to that late documentation, and the tribunal will make the final decision, although will probably be guided by what is in the interest of the child concerned. And when I'm talking about a child concerned, it's also important to remember that a child will not be present. A child is the subject of the appeal, will not be present for the hearing, although there are circumstances, and if relevant, where the viewpoint of a child can be obtained, and this can be considered by the tribunal. So during the hearing, the tribunal members will take careful notes, will listen and ask questions, and as a chair, I will guide the discussions. Sometimes the education authority will have legal representation. However, our informal format discourages any formal legalistic input from lawyers. And as a chair, I will always ensure that the hearing does not move into a them versus us framework. Time for comfort breaks is also given, and that's to be encouraged. And it is essential to enable all the parties to give their position and to have their say in as full a way as possible. Sometimes emotions come to the fore, and that's very understandable in the circumstances. But again, it is essential that everyone has their say on these issues. At the end of the hearing, when all the issues have been properly dealt with, there's an opportunity for each party to sum up their position in relation to the appeal. And once that's happened, the hearing comes to a close and the parties leave the hearing room. And after that, we as a tribunal will spend time reaching a decision, and we will take into account everything that we've heard at the hearing and everything that's contained in the documentation. A decision is not reached on the day of the hearing. We as a tribunal aim to provide a written decision to the parties within a period of 28 days. However, that may not always be possible. Sometimes there are complex issues to be considered, and a written decision is sent out to the parties. A decision is not given on the day of the hearing, and it's not given on the phone. When a decision is received by the parties, an appellant may want to consider whether or not they would like to appeal the decision. And an appeal is allowable on a point of law. And that's when it is sometimes useful to seek clarification either from the tribunal secretariat, who would hope to be able to be in a position to deal with your queries, or you may want to speak to someone, for instance, like SENAG, who can give you advice and support as to your possible next steps. And that's very often maybe would involve getting legal advice as well, but it's very much a decision that can be made by yourselves. So that's really been a sort of a run through. It's a very quick run through of the process and what to expect on the day of the hearing. However, the essential takeaway from what I've said to you would be that it is a very user-friendly format, and that we aim to allow the appellants to feel comfortable, to encourage them to have their say, and to feel that at the end of the day they've been listened to in an environment which encourages them to have their say in a very informal environment, as I've previously referred to. So thank you very much for giving me the time to talk to you today, and I hope that that's been of assistance to you. Thank you and goodbye.